It's my great pleasure to welcome you all here today and to introduce our speaker. Deborah Tuerkheimer joined the Northwestern University School of Law faculty in 2014 after serving as a professor of law at DePaul University since 2009. Among her many claims to fame is that she is the daughter of Barbara Tuerkheimer and our own Professor Frank Tuerkheimer. Excuse me. Deb, and I'll call her Deb if that's okay to distinguish her from our other distinguished Tuerkheimers here, received her undergraduate degree from Harvard College and her JD from Yale Law School. She teaches and writes in the areas of criminal law, evidence, and feminist legal theory. After clerking for the Alaska Supreme Court, Justice Jay Rabinowitz, she served for 5 years, which is interesting for our topic today. She served for 5 years as an assistant district attorney in New York County District Attorney's Office, where she specialized in prosecuting domestic violence and child abuse prosecutions. She is now one of the world's leading authorities on the medico-legal issues presented by the law's heavy reliance on medical opinions and medical hypotheses to prosecute so-called shaken baby syndrome cases. Her first article on the topic, entitled The Next Innocence Project, Shaken Baby Syndrome and the Criminal Courts, which was published in 2009, was a groundbreaker in the field, and it's one that is widely recognized and cited in litigation around the country. She followed that article with an equally insightful and important article, Science-Dependent Prosecution and the Problem of Epistemic Contingency, a Study of Shaken Baby Syndrome, that she published in 2011. And most recently, just earlier this year, she published her book, Flawed Convictions, Shaken Baby Syndrome, and the Inertia of Injustice, with Oxford University Press, setting another major milestone in the field and providing the background for her talk here today. So I am thrilled that she's here today to talk about her book and her important work in this field. Please welcome Professor Deb Tuerkheimer.
Thank you. Thank you so much, Keith. I really appreciate the invitation to be here, and it is quite extraordinary to be here at the University of Wisconsin Law School. I can truly tell you that this has been a special place for me my entire life, and it means a lot to be here today. It means a lot to be speaking about this topic in particular at the law school that has amassed the greatest collection of the nation's leading experts on shaken baby syndrome. So, of course, Keith Finley, Carrie Sperling, and Kate Judson all have really marked the University of Wisconsin Law School as the center of intellectual life around this problematic diagnosis. And it really is a privilege to be speaking with you in the room. So by way of introduction, let me describe the shaken baby syndrome prosecution paradigm that emerged in the 1990s. And I want to talk about the trial and conviction of Jennifer Delpreet. She was tried in Illinois in 2005, and I use this case to illustrate the typical progression of an SBS diagnosis. So please indulge me just for a moment. I'm going to read from a portion of the book that describes, introduces what this case is about. Jennifer Delpreet cared for children throughout most of her life. An older sibling, an assistant preschool teacher, a nanny, the head of a church nursery, a youth librarian, a school room mom, and most important, a single mother of her school-aged son and daughter. She was adored by children and admired by the adults who observed her with them. When a long list of character witnesses would later testify on her behalf, they would consistently remark on her patience, kindness, and extraordinary way with young people. In August 2002, Delpreet began working at a small home daycare in a Chicago suburb, which was owned by a woman with whom she had shared room mom responsibilities. The collapse of a baby in her care occurred just after Christmas. It was the first holiday ever that Delpreet had paid all her bills in cash. As she later recalled, I was proud and relieved and happy. My children were happy. It was a great week that turned out to be a nightmare. Around noon, 4-month-old Isabella awoke from a nap. Delpreet later told the police that she changed the baby's diaper and clothes on the couch and prepared a bottle. When she returned, Isabella's eyes were half open, her breathing was labored, and her body was limp. Delpreet attempted to revive her with a slight shake while calling her name and patting her on her back to dislodge whatever might have been blocking her airway. After an unsuccessful effort to give the baby a bottle, Delpreet grew frantic and called 911 before beginning CPR. Almost 3 years later, as the caregiver stood ready to be sentenced for first-degree murder, she spoke directly to Isabella's parents. And this is what she said. Isabella was my friend. I loved her, although I knew her only for a little while. My kids loved her. We would sit together and smile at each other. I would comfort her when she cried. I fed her, changed her, and watched over her safety. I am sorry I couldn't do more to help this poor defenseless baby while struggling to survive. Believe me, I tried with everything I had. If your mom would have watched her that day, it would be her sitting up here defending herself for something she did not do. Or if you would have been with her that day, it could have been you. I did everything in my power to help your little girl. The witnesses against Jennifer Delpreet were 4 doctors who testified for the prosecution: an emergency room doc, a pediatric critical care specialist, a child abuse pediatrician, and a forensic pathologist. These doctors had no doubt whatsoever that the so-called triad of neurological symptoms meant violent shaking by the person last with the baby, Isabella. So this is the prosecution paradigm. The state presents medical experts, sometimes a few, sometimes a dozen, to testify to every element of the crime charged. The basis for this diagnosis, again, is the triad of neurological symptoms: bleeding beneath the outer meningeal layer of the brain, and that's called subdural hematoma, bleeding in one or more retinas, retinal hemorrhage, and brain swelling or edema. Based on this triad, these 3 symptoms, doctors purport to know, first, that the baby was shaken to death or serious physical injury. Second, that the force of the shaking was so great that the perpetrator must have possessed the mental state necessary for the commission of the crime. And third, that the perpetrator was the defendant. So on this last element, identity, the state's doctors typically testify that the severity of the neurological injuries means that the baby's collapse would immediately precede the shaking episode. So what that means is that the last person with the lucid or conscious baby must be the abuser. So SBS is what I have referred to as a medical diagnosis of murder. The expert scientific testimony is used to prove every element of the crime charged. Delpreet was sentenced to 20 years in prison. The problem is that scientific understandings of this diagnosis have evolved. There has been a shifted consensus about the meaning of these 3 neurological symptoms. And while there is considerable controversy surrounding the validity of the diagnosis, whether it even exists, again, there is considerable consensus, even if it exists, about what it is. One mark of this is the 2009 American Academy of Pediatrics position statement, which adopted what it called the less mechanistic term of abusive head trauma in place of what was previously known as shaken baby syndrome. This latest nomenclature incorporates what the American Academy of Pediatrics concedes is a, I'm quoting, less certain diagnosis. So here are the new unknowns. And I'm going to argue that these new unknowns matter a lot from the criminal justice perspective. First, unknown force. It's now accepted that falls from a short distance can bring about the triad. And that minimal force, or even no force at all, can reactivate old bleeding, which is present in many of these cases. There's also a body of biomechanical research that suggests that it is not possible to bring about the triad of symptoms without implicating the cervical spine or neck. And that's the body of research that undermines even the possibility of triad-only diagnosis. But we can put that aside for purposes of much of my argument, and this is where there is considerable controversy. Second, unknown origins. So there has evolved what is known as a differential diagnosis, which is a list of possible explanations for the triad. No longer do doctors claim that the only way these three symptoms could have come about is violent shaking. Instead, a number of possible explanations must now be considered. And many of these explanations are non-traumatic. So for instance, this is the standard list: congenital malformations, metabolic or genetic disorders, hematological disorders, infectious diseases, autoimmune conditions. Other possibilities include aneurysms, stroke, chain reactions to cardiorespiratory arrest, hypoxia, resuscitation, and seizures. And then there is disagreement about other potential causes, including cerebral venous thrombosis and benign external hydrocephalus. Many unknowns in place of the certainty that once was used to convict so many caregivers. And finally, when we think about the new unknowns, we have to think about timing, unknown timing. It is impossible to pinpoint with any degree of certainty a time frame during which injury supposedly occurred. And this is now generally accepted. So where once doctors would testify to the identity of the perpetrator based on the onset of these apparent neurological symptoms, it's now accepted that lucid intervals do exist, a period of time during which a baby may be experiencing these symptoms and yet appear to be well. So overall, we now recognize that certain claims made on behalf of the triad in the past were incorrect. And as it turns out, the scientific basis for hypotheses surrounding shaken baby syndrome is weak. Audrey Edmonds, the Wisconsin caregiver represented by Keith Finley in the Wisconsin Innocence Project, saw her 1996 conviction undone for just these reasons. Her case, too, is paradigmatic. The same expert testimony, the same medical certainty, based on the same triad, convicted her and resulted in an 18-year prison sentence. But according to the Wisconsin Appeals Court, writing more than a decade later, a shift in mainstream medical opinion undermined the validity of the diagnosis. Without the science upon which her conviction fully rested, there was every reason to believe she was innocent. Her case was later dismissed. I started researching shaken baby syndrome in early 2008 when I read the Edmonds opinion. As Keith mentioned, I had spent time as a prosecutor, and the cases that I handled included child abuse cases and shaken baby allegations. So I was trained on this paradigm. I was told by my experts that the triad of symptoms necessarily meant violent shaking by the person last with the lucid baby. And as far as I knew at the time, there was no doubt that this is what those medical symptoms meant. So when I read this opinion in the Edmonds case, my first reaction was that the appellate court must have gotten it wrong and that this was something worth looking into. I started doing the research. Keith was kind enough to send me the entire transcript from those post-conviction relief hearings at which Edmonds presented her experts, the state presented its experts. I started looking into the medical literature. I started talking to doctors and prosecutors, and ultimately came to believe that this was a problem of staggering proportions that the criminal justice system would now have to deal with. Because again, this is a category of cases with functionally similar facts. this triad of symptoms, the medical testimony, are all so similar that if the science underlying Audrey Edmonds' conviction had shifted decisively, what would happen to all of the other caregivers whose convictions rested upon that same flawed science? My thought was that the criminal justice system would need to respond and that we would all put our heads together and figure out how that would happen. What I didn't predict was that the cases would keep coming. And that's been, over the years, something that's been difficult to understand, why some of this same flawed science continues to make its way into criminal court. There have certainly been signs of progress, and I will talk about those at the end. But when I first went into this research, my thought was that the real issue would be undoing these convictions that were already on the books. Now, I expected that there would be fairly quick progress, but that was naive. What I found is that this is a system that is very difficult to move, and that the course of injustice is difficult to right. So let me highlight just a few key points about the limits of judicial review in shaken baby cases, and then I'll spend my last few minutes situating this problem in wider criminal justice context, because I do think it is a case study in many of the problems that arise in science-dependent prosecutions. So on judicial review, the basic observation that I would make is this. Once a defendant is found guilty or pleads guilty, judicial review is not an effective way of vacating convictions that rest on doubtful or doubt-filled evidentiary foundations. This is why I call the book Shaken Baby Syndrome and the Inertia of Injustice. So I recognize that finality is an important criminal justice norm. But these cases expose a system that is too primed to stay the course. If, that is, we are committed to a reasonably high standard of proof of guilt, to say nothing of freeing the factually innocent. So let me talk about sufficiency challenges first, and then I'll talk about post-conviction relief. So my 5-year survey of SBS cases shows that sufficiency challenges are summarily denied. Sufficiency challenges are challenges to the adequacy of the evidence that convicted a defendant. The argument is that no reasonable jury could have found the defendant guilty based on the evidence that was admitted at trial. When a court is asked to review the sufficiency of the evidence, the answer seems fairly obvious to these appellate courts. So even where a defendant presented experts of her own to testify to a very different medical picture, the jury is free to credit the state's doctors, right? It's within the purview of the jury to assess credibility and essentially to choose a side. In a battle of the experts, a guilty verdict simply means that the jury picked the state's. With only one exception, the Shirley Smith case with somewhat unusual facts, no court has said that this conclusion is unreasonable. With little or no inquiry, courts simply conclude that it's within the jury's purview to determine the credibility of expert testimony. Conviction means that the state's experts were more persuasive. That's the conclusion that the appellate courts come to, again, with really little analysis. A few observations about what this kind of sufficiency review overlooks, or what the limitations of this kind of framework might be. First is that given how this testimony is usually presented at trial, and this claim is based on my reading of many trial transcripts, I am skeptical about whether juries are making these judgments in a way that is reasoned, much less reflective of the best available science. A related point is that the criminal law has no developed framework for considering the interplay between evidentiary admissibility and legal sufficiency. So I won't say a lot about evidentiary challenges here, other than to note that they have been largely unsuccessful. But I do note that the standard for admitting this kind of expert testimony is exceedingly low. at least in the criminal context, even lower than in the civil realm. It turns out that criminal courts are barely even scrutinizing the content of prosecution expert claims. Were judges to take a more active role in regulating the substance of these expert claims, then sufficiency review might have some bite. I do think that there's a complicated relationship between the kind of evidence regulation that I have in mind and appellate court review of the sufficiency of the record. And again, I sort of call upon in the book trial judges to do a better job of regulating the scope of expert testimony, sort of like judges do in the civil realm. And if that were to happen, then I think these records would be found wanting when appellate courts look to do sufficiency review. Okay, a few words on collateral attack. Again, over the past decade plus, SBS has become a far less certain diagnosis. And for my purposes here, we can even put aside the argument that SBS is an entirely invalid diagnosis, meaning that it cannot exist, the triad cannot exist without other medical signs of abuse. When I say the diagnosis has become less certain, again, I'm referring to understandings that are reflected in the leading medical treatises, medical journals, and official statements by the leading organization of pediatricians. So most important, there are other natural causes of the triad. The force thresholds required to cause injury are unknown, and there can indeed be lucid intervals. So we might expect that defendants convicted by the old science that has been discredited would be able to successfully claim post-conviction relief. Some have, but many more, hundreds more, have not. One significant problem is the framework of newly discovered evidence. The model, of course, the gold standard is DNA. Our criminal justice system has oriented itself around DNA testing as the way to prove innocence. And every state and the feds now have statutes that facilitate this type of exoneration. But in SBS cases, there is no test for innocence. To be sure, it can happen that after trial, new experts take a look at the baby's medical records and find a single alternative cause that seems exceedingly likely. Okay, and these are the cases that, unsurprisingly, tend to result in post-conviction relief, where you have that single cause that the defense experts converge upon after trial. Okay, those are good cases for folks who want post-conviction relief. But more often, this doesn't happen. The petitioner is pro se, lacks money for experts. The defense experts disagree as to what might have happened, or maybe even admit uncertainty as to why the baby collapsed. On this point, it's helpful to know that some tests on the differential diagnosis can only be performed on autopsy, and others can only be performed in the clinical setting. So depending upon whether the baby lives or not, some tests are foreclosed. So in these cases, the new evidence is new reason for considerable doubt about the evidence that convicted. But undermining proof of guilt is generally not good enough for reviewing judges, especially where the original trial featured some challenge to the diagnosis, however feeble, right? And so in cases that we see that are more recent cases, the defense is mounting a challenge to the prosecution's evidence, and those cases are even more difficult to undo. In practice, the newly discovered requirement is a barrier to relief not only for SBS defendants, but for anyone who lacks affirmative proof of innocence that resembles DNA. Okay, so this may be about to change. By way of update to my manuscript this spring, Judge Matthew Kennelly in the Northern District of Illinois issued an opinion in the case of Jennifer Delpreet, the case that I began with. As you recall, she's the caregiver, whose prosecution I described as the paradigmatic case. It seemed when she was tried in 2005 like an airtight case. And again, I call it paradigmatic because the testimony against her was standard fare. But according to Judge Kennelly, writing a few months ago, by a preponderance of the evidence, no reasonable jury would convict Delpreet today. She has passed through the actual innocence habeas gateway, which now allows her to proceed on her ineffective assistance claim. Despite having procedurally defaulted on that claim, she can now go forward. What's most relevant to this discussion is the judge's opinion and its emphasis on problems with claims made by the state's experts at trial. So much of the testimony that convicted her was, in retrospect, and with the benefit of 9 days of evidentiary hearings, flawed. A remarkable passage in this opinion states that arguably a claim of SBS is more an article of faith than a proposition of science. I think Judge Kennelly is analyzing the miscarriage of justice exception as it should be analyzed. Rather than put the burden on Delpreet to explain what happened to baby Isabella, Judge Kennelly looked at the lack of evidence of her guilt and determined that there wasn't enough. She's now free on bond, Delpreet, and will likely soon prevail on her ineffective assistance of counsel claim, although she's got a Brady claim that's now making its way through Illinois State Court before she gets back to Judge Kennelly. Perhaps to state the obvious, I'm going to say it anyway, habeas is clearly not an efficient way of remedying injustice, particularly for a category of cases with functionally similar factual predicates. Recall that Jennifer Delpreet spent a decade in prison. To pull back for just a moment, I want to suggest that SBS is an object lesson in the dangers of crossing science and criminal prosecution. What I call science-dependent prosecution surely comes in degrees, and it is certainly here to stay. So part of my critique is aimed at retrofitting our system to better deal with scientific contingency and the fact that science does evolve. I should add, by way of conclusion, that SBS is also a case study in the criminal justice repercussions of too little epistemic humility. We see this from diagnosis to confessions to trials and guilty pleas, and of course, to judicial review. I talk about all of these issues in my book, and I'm more than happy to take your questions about any of it here today. And again, I thank you very much for having me here.
Questions?
Do you have an estimate, Deb, about how many people are in prison with SBS convictions?
Yeah, it's a great question, and it's one I get asked a lot. I have an estimate, although before I give you that estimate, I'm going to tell you that the Medill Justice Project at Northwestern University is gathering the first national database on SBS cases, and they're currently releasing that database to the public in stages. So they've collected over 1,000 cases. Not all of those cases have resulted in a criminal conviction, and certainly not all of those cases involve someone who's currently serving time. Based on the appellate case law, based on the media reports, we know that 1,500 diagnoses or so are given a year. Of those, I would say that there are a few hundred people who are currently in prison based on this diagnosis. That's an estimate.
In any of the cases that you've researched, did any of the defendants take polygraph tests?
So polygraph tests are often, part of the interrogation. The question is raised, will you take a polygraph test? In one of the cases that I talk about in some detail, the suspect agreed to take a polygraph test, and then because she was pregnant, it turned out she couldn't, and by the time she could, she had a lawyer and she did not take a polygraph test. I should add, she was ultimately found not guilty, this woman. As to whether any of these defendants actually took the polygraph test, I'm really not coming up with any. I don't know if Keith or Carrie, you know of any of these defendants who have taken them?
Yeah, I've had cases where they do, yeah.
And where they do and they pass the polygraph, does that give the prosecutor pause whether to bring the charges or not?
Not in my experience.
Deb, thank you. That's really fascinating. And I find myself thinking more generally about the problem of how to use science in the criminal courts, which you alluded to but didn't get a chance to expand on. So given that science always has a mix of opinions, and given that doctors actually aren't scientists and may not be the best position to evaluate evidence across multiple studies and doing meta-analyses, what are the procedural protections you imagine might help in the future in either shaken baby or in other cases like arson, where also it turns out that scientific evidence is crucial to key elements of the crime?
Thanks. It's obviously a really important question, and I don't purport to have all the answers, but here are some thoughts. In the civil realm, where large amounts of money are at stake, there is developed a far more sophisticated framework for admissibility determinations. And so experts are, particularly where they're opining on causation, judges are requiring those experts to defend their conclusions based on scientific methodology in ways that, albeit imperfect, are far superior to what we see in the criminal realm. So at the outset, I would sort of like to see more of a similarity, more of a resemblance between what's happening in criminal court and what's happening in these civil cases. Again, it's not that mistakes can't be made in these civil cases, but I don't see why there should be this incongruence between the way judges are making admissibility determinations in criminal court and the way they're making these determinations in civil court. I would point out that some of these experts probably shouldn't be opining on the areas that they're opining on, and that if judges were sort of limiting the scope of expertise to what these doctors actually could state to some sort of reasonable degree of certainty, I think that would go some way toward actually restricting the testimony that was coming in. And then frankly, forcing doctors, if they can do it, to talk about the scientific literature and the scientific basis, if any, for the claims that they're making in court. That's not happening in these cases. Judges are simply saying, well, we've always allowed this kind of testimony in shaken baby cases. We're not even going to look back and sort of reconsider or think anew about whether the scientific basis for these claims is valid. It's, again, this sort of idea of inertia. We've been letting it in all along, and there's no need to go back now and revisit those conclusions.
Okay. Kind of a follow-up from what you just said. Have you found any cases where a judge has been willing to say, okay, you're a treating pediatrician, therefore you can't testify on timing, or you're a radiologist, therefore you can just testify as to imaging? And then another on that, based on the more modern cases where there has been kind of an aggressive defense about the diagnosis or the lucid interval, have you ever talked to jurors in the cases where they lost to say, how did you reconcile this medical degree of, reasonable degree of medical certainty where you had competing experts, yet you still found this? Sorry, that was a lot, but. Yeah,
that's a great idea. I've not spoken to jurors in these cases, and it would be really interesting to do that. So the cases where courts have restricted expertise are not in the shaken baby area. There have been a couple of decisions limiting what prosecution experts can say. When I say a couple, I literally mean two. One was overturned. So it's slim pickings. As far as sort of the reasonable degree of medical certainty and how that translates into proof beyond a reasonable doubt, I'm fascinated by that question, because those are different standards, right? And you could imagine having a number of doctors come in and testify to a reasonable degree of medical certainty, and that's all there is. And to go from that to being convinced beyond a reasonable doubt of guilt, I think is a big step. There's actually an interesting case, and if you want the site, you should come talk to me after, out of New Mexico, just very recently, where a court has sort of finally kind of focused on this potential problem and has made the point that it may well be that those two standards are too different for reasonable degree of medical certainty to somehow be transformed into proof beyond a reasonable doubt without more.
To what extent are the defendants that you're talking about and been looking at, to what extent do you feel they are innocent, and to what extent are they not proven guilty?
So I think the reason the question is difficult to answer is because the difficulty of going back into these cases in any kind of thorough way with the right experts who are asking the right questions, I think makes it nearly impossible to assess what really happened to the baby. So, I sort of confront the limits of those procedures when I think about the question that you just asked. It does seem to me that when competent experts go back in and look carefully at these records, there is a plausible medical explanation that arises in most of these cases. But in most of these cases writ large, that's not happening. So all I can see in those cases is a flawed evidentiary record that makes me think this is not guilt beyond a reasonable doubt. What I would like is this has sort of been my hope all along, is that there would be some kind of systemic review of these cases so that we could answer that question. We could sort of start to think about what is the likely possibility. What is it that we think happened to this baby, medically speaking? And maybe that some of these are mysteries and that we can't solve those mysteries, but I think that in many of these cases there's old bleeding that either wasn't known at trial or wasn't discussed at trial, and that in itself seems really significant to me. I mean, if this is a child who actually had neurological symptoms at the time he or she came into the care of the defendant on trial, I think there's got to be at least some effort to understand what it was that was already going wrong.
Thanks. You mentioned that there are some cases where the baby survives, and my impression was that almost all of these cases are the opposite, right, where the baby dies. And so I wonder if you could just speak a little bit more on that distinction. What percentage of these cases would you say are examples of the baby, surviving, and then how do those cases look different from the cases where the baby has died?
Yeah, so the cases where there's not a death are increasingly finding their way, I think, into the child protective system. And so if there's a baby who's died, it is far more likely that police will get involved. There will be an interrogation and often a prosecution. And so those cases, I think, are being channeled into the criminal justice system. Criminal justice system also deals with cases where there's not a death. But again, increasingly, what's really interesting to watch is the sort of movement into child protective court where there's a lower standard of proof. And so in cases where now the prosecutor is saying, I can't take this, I can't prove this beyond a reasonable doubt, many of these parents are losing custody of their child or children nonetheless, because someone decides that there's enough evidence to go forward in that realm. And so those parents the baby tends to live, but those parents also tend to have means. I mean, there's a real resource inequity issue here. Many of the stories that I tell involving parents who lost custody of their child but then regained that custody, those parents will be very upfront about the fact that they were able to afford a lawyer from the outset. They were able to hire really good experts, and sort of there, but for the grace of God, go I, is the impression that I get from many of the people I've spoken to who could afford to mount the most effective defense from the outset. And, things turn out relatively well for them. That said, the happy ending is pretty awful, right? I mean, the happy ending is losing custody of your child for some length of time, which no parent, should have to endure, a parent who's innocent and did nothing to harm this child. But, as compared to 20 years in prison, it looks pretty good.
So I have a follow-up on Alta's question earlier, which is to ask about the post-conviction side of relief when science changes. So tightening up, sorry, Cecilia.
I could not find that voice. Okay, thank you.
No problem. Tightening up evidentiary standards will help on the front end with current prosecutions in cases where the science is at issue in ways it once was not. It won't prevent current states of knowledge from changing in the future, and it doesn't remedy those areas like SBS cases and arson cases where we currently see an undermining of what was previously thought to be known. Do you have any thoughts on what a systemic response looks like, not just for SBS cases, but for all cases now and in the future where we have doubt about the validity of convictions based on changes in scientific understanding?
Yeah, so thank you. This was the question that I sort of thought I was going to set about answering when I first looked into this, right? So what are we going to do about these old convictions? How are we going to sort of systemically review them so that we can, maybe get a better sense of who should be freed? There is the so-called, this new law in Texas. It's named the junk science law, and it provides an additional grounds for habeas relief, very much geared at the arson cases, and these child death cases where the science has changed and defendants are explicitly granted this additional basis for habeas relief. So I think that's good, and I think that more states should pass that kind of a law, but I don't think that that's really going to solve the problem given how few of these petitioners have counsel and again, the inefficiencies of habeas review when we're talking about a category of cases. A couple other thoughts. There are innocence commissions like the one in North Carolina that could be created to deal with a particular problem like SBS or a larger problem of sort of the criminal justice system and errors that we now know are made. I also think about prosecutors' offices and this trend toward conviction integrity units that are housed within prosecutors' offices. This does seem to be a growing trend. Some seem to be doing institutional design more effectively than others. But for prosecutors who take seriously, Dallas County is sort of a good example, I think, take seriously the obligation to remedy injustice, there are some efficiencies there. I mean, the prosecutors are the ones that have the case files and that can easily get hands on these cases in ways that others may not be able to. Obviously, there are the problems of institutional bias, right, and tunnel vision that Keith has written about. So I'm not suggesting that that this is the perfect solution either, but I think it's worth thinking about. And I think that there's not going to be a single solution to the problem. So if the criminal justice system just generally reorients to the idea that errors are made in these cases and that finality cannot trump a desire to go back in when there's some threshold that suggests that perhaps there was a mistake, that's all for the good. I'm speaking in a couple weeks at a conviction integrity conference in Chicago where the audience is prosecutors. I've never done that before. I think it's a great development that this is happening, and there's going to be a panel on common causes of wrongful convictions. We'll see what happens, but to my mind, it's a really positive development that these conversations are happening, frankly, with people who are in a position to do a lot of good if inclined to do it.
Deb, I wonder if I could follow up on one of the other exchanges you had earlier where I think you started to talk about this, but I wonder if I could push you to talk a little bit more about it. And that's one of the interesting points you develop in the book about the differences between criminal and civil courts and the way they handle evidence, and in particular, the distinction you draw between, and that the civil courts seem to draw between this notion of a differential diagnosis and a differential etiology.
Yeah.
So I wonder if you could just sort of expand on that a little bit.
Sure. So thank you. So the differential etiology is a question of external causation, right? This is how civil courts have identified the meaning of differential etiology, and generally distinguishing that concept from what is known as differential diagnosis, which is eliminating other possible diagnoses. Okay, so if somebody presents with some symptoms, what could be the cause of these symptoms? But in terms of the identifying the disease, not some external process that brought it about. So if somebody goes to the doctor and says, my back hurts, right? Maybe it's a slip disc. Okay, so maybe that's one of the possible diagnoses that, maybe there are others. But the doctor is not in all likelihood going to determine how this person injured his or her back or purport to do that based on some sort of scientific methodology. I mean, the doctor might ask, how did you do this? What did you think happened? And that might figure into the determination of, what the medical diagnosis is. But the notion that the doctor is ill-equipped to determine this external causation is very deeply embedded in the civil case law. Right, and so going to Alta's question earlier, medical doctors have expertise in particular areas. Child abuse pediatricians treat children, right? And so they have clinical expertise. But on this question of what caused these neurological symptoms, right, they really don't. Okay, and the problem is that shaken baby syndrome is a medical diagnosis, but it essentially builds in this question of external causation. And so it kind of, it sort of in very subtle ways, it's etiology disguised as differential diagnosis. And what the hope is that criminal courts will start to see this and will start to hold these experts to the same standards that they're being held to in the civil realm, where they come into court and they're told, you can't testify as to external causation. You don't have the scientific basis to make those claims.
How much of this do you think, lawyer dependent, in that the civil cases are generally litigated by lawyers who are used to this kind of language, used to dealing with scientific evidence, versus criminal defense lawyers who seem not to be?
I think there's some of that. I mean, there's too great a sort of distinction between the lawyers who practice in criminal court and specialize there, and I think frankly some of this is the ability to fund these high quality defenses that you see in the civil realm. And there's some interesting work that's done outside the SBS context about the ways that admissibility determinations are made differently in the criminal context and the civil context. And so I sort of draw upon some of that work and say, sadly, this is probably not unexpected that we see this sort of distinction. But again, it doesn't rest on any kind of rational basis. I don't think it can be justified. It's simply an artifact of this, this world in which we live, that we like to think we have this equal system of justice.
I'm hoping you can talk a bit about the confessions that I'm guessing you found in a number of these cases. Mm-hmm. It seems like SBS is a type of charge that would lead to more false confessions, and those false confessions would also make it more difficult to beat the charge in the end.
Right. There's so much to say about confessions, and you're right, particularly of late where the medical testimony is weaker and it's being challenged by the defense, there's more pressure than ever to exact a confession. And so I study these interrogation transcripts, and I try to look to the literature, the social science literature on unreliable confessions and the factors that lead to false confessions, and try to juxtapose the two, because what we see is that many of these cases, are, just sort of perfect exemplars of what should not happen when detectives are doing these interrogations. The conditions are ripe for false confessions. And so in many of these cases, the interrogations are long. These are caregivers often with an emotional, stake in the health and well-being of the baby. They're told, if you simply say this, you can see the baby maybe in the hospital still. So the pressures that are brought to bear are enormous. And I think, from my perspective, most interestingly, maybe most importantly, the detectives are fully certain that this is how it happened. And there's only one right answer to the question of how the baby collapsed. It has to be shaking, right? And so when presented with that kind of certainty, which is based on the certainty of the doctors, I mean, this all sort of connects, right? Everyone's convinced, the doctors are convinced, and so therefore the detectives are convinced, and frankly, they often end up convincing these suspects. Many of the suspects talk about shaking in the course of revival efforts. But by the end of the interrogation, at least in a few of these cases, the suspect is convinced that shaking after the baby sort of went blue is what caused the baby's death. And of course, the timing is completely off. But they're so persuaded by the utter conviction of law enforcement officials that they had to have been the cause of this. It's really pretty tragic. In one of the cases that I'm thinking about, it was a father who by the end, was just absolutely overwrought at the thought that he had done this to his daughter. And it's pretty awful to read the transcript. I should say he was found not guilty. So there, your intuition is absolutely right that once a confession is exacted, it becomes much more difficult for the defendant for obvious reasons. These confessions carry a lot of weight with jurors. In this particular case, the jury said no.
Deb, I don't do criminal law, so I'm unfamiliar with procedural options and jurisdictional issues. But although it's changing now, by and large, judges and lawyers are not particularly well schooled in science. And so for years, there have been thoughts about a science court that's been dismissed for many other reasons. But occasionally, there's a topic where it seems like there's a concentration of problems and a dearth of expertise that would suggest the need for some kind of central mechanism, right? You're not going to have enough experts across all the untold number of counties in the United States to be able to deal with these piecemeal. Is there any method by which one could identify a category of cases? You've identified SBS. Cecilia mentioned arson. I suspect that SIDS was at one time at the center of some of this as well, by which the criminal justice system is capable of actually allowing for some kind of centralized expertise to review and advise in a more organized way with deep appreciation of what's going on in the records.
It sounds like a fabulous idea, and it would be wonderful to have some precedent to draw upon for what you're talking about. I don't know of any. I just don't think the criminal justice system has ever done that. Keith, Carrie, Cecilia? But it should.
The closest I can think of is, and it's not by any means binding authority, but it at least is a centralized sort of authoritative statement, is something like a report by the National Academy of Sciences.
But that's not going to be case by case. I mean,
No, that's what I'm saying. It's not case by case.
Because it's done in the research ethics, research regulation context.
So you're talking about a case by case authority.
Somebody that goes back to all of the cases, reviews all the records, and because you've got a group of experts that are now deeply schooled and can actually keep learning from each record that they review and advise. Otherwise, no matter how well-intended your prosecutors are after you give them that speech in Chicago next month, they themselves are not necessarily going to be able to have the expertise or call on enough experts to really go over those records the way you want them to be gone over.
Right, and I guess I would say that the closest parallel would be this North Carolina Innocence Commission that does try to amass this kind of expertise. You could do that, I suppose. I think understood the question to be directed more at the pre-conviction level. But post-conviction, sure, this would be sort of the innocence commission model that would do just exactly what you're saying. And I advocate for that in the book.
Okay, with that, I think we've come to the end of our time. So I hope we can all give Deb a big thank you for her talk today.
Thank you all. Thanks.